Welcome to the July 25th, 2019 Charter Review Task Force. I'm Gary Hesketh. We have 3 members missing of a 7-member team, but we still have a quorum. I'm expecting one to come a little bit late, but we still have a quorum, so we'll conduct business. First order of business for the task force members is let's review our calendar and look for future dates. Today's the 25th. We have scheduled a task force meeting next Tuesday on July the 30th here at 6 o'clock. We have another task force meeting on Tuesday, August the 6th in this room at 6 o'clock. We have another on August 13th, which is Tuesday at 6 o'clock. And then we have a participation session on Monday, August the 19th, which is being hosted and facilitated by Kathy. And I'll let you discuss that now if you'd like to speak to the audience.
Yeah, we were fortunate enough to have a session a few Saturdays ago where we invited the community in. There were 4 topics, and we did group dialogue around those issues and challenges and switched tables. And it was a very powerful, I think, experience. We're collecting the data from that and going to have the same questions available on August 19th. So please join us. Could we meet your neighbors, too?
If you don't mind, can you give us an idea of how the 2 sessions will be combined, the data will be presented to the task force
Yes.
when it's complete?
So we have a big piece of chart paper in the back and Post-it notes with thoughts from our community members under each topic. We're going to add the next group to that. And then what I will ask of the task force is to sort those into common themes and address those common themes that we hear. And for some of the topics, there were very consistent common themes from the community. So that's what we need to pay attention to as we go through the process. So we'll be finishing that after we do the 19th.
All right. Now, the topics of our interest to the community is director term limits, group homes, and medical treatment facilities or something to that effect. And
Term limits?
No, there's, yes.
No, that was the one
Oh, sorry.
said.
How do you bring something to the
How we
table?
bring something out to the board of directors, how does the public do that? So, and the RFP, request for proposal process to select a management agent for program. So those are the 4 topics we discussed to get input in that meeting.
Correct.
Visit. That meeting on the 19th of August is in the evening at 6 o'clock. All right. So now I'd like for the task force to open up your calendars and let's look for future dates in September. So the town hall can put those on the schedule. And of course, all these dates will be online on Friday Flashes, as well as the online calendar at the Celebration website. This room doesn't have availability all the time, but what is available is either the 16th or 17th of September, Monday or Tuesday, and on the 23rd and 24th of September, Monday and Tuesday, and I'd like to pick one date from each of those weeks. Now, there is a CCDD meeting on the 17th at 6:30 that several members of the board and the task force attend. That might lean us toward Monday the 16th.
I've actually got is there a Crow workshop? I've got the
There is at 9:30 in the morning.
No.
And we'd be meeting at 6 o'clock.
Guess I should change that. It's not at 5
How
p.m.
about the other 3 of you, Leslie and
You
Bill?
said 16th
Does
or
the 16th of September sound good?
It's fine.
Yeah.
Okay.
Mondays as a rule are my favorite, and then Tuesdays.
Oh, all right. So I'm going to put down task force meeting, 6 o'clock on the 16th. And then your choice, the 23rd or 24th of September. What looks good for you 3?
What were those again?
23rd and 24th, Tuesday, and Monday and Tuesday.
Neither of those work for me.
Neither for me either.
It's
Yep.
Seattle
Yes or no? Leslie?
that week.
No, neither one? Oh, Bill?
At the moment, they both do.
Well, we'll have to, we have Jack McLaughlin and and Greg and Eileen, who we can discuss. Let's tentatively, we'll leave those 2 dates open, and next week we'll figure it out.
Okay.
How's that? Okay? So we got one more on the schedule and one
110
yet
days.
to go. All right. Now, for the audience, we will have public comment, but not to delay the lawyer any longer. We're going to have him speak and answer a few questions for us that we given him a couple of weeks ago. He's all, for the task force team, he was nice enough to provide us with written responses, which I've already incorporated in your version of the issue sheets, version 8, dated the 21st. So as we go through the questions, he's going to respond in general of what he provided. You can follow through on the issue sheets. For the audience, I'm going to read the questions we posed to the lawyer, Thomas Layton here, and then he'll give the responses. So question 1, we asked Coral Legal to provide an example of minimum requirements would be to allow group homes or residential treatment facilities for inclusion in the charter. For the task force, if you look at tracking number 1-2, you'll find that. And I'll send it over to Tom to see what he can tell us.
Oh, sure. Thank you. And good evening, everybody. In answer to the first question, the rules and regulations and court cases that interpret them regarding group homes or the allowance for group homes are constantly changing. And so we weighed putting something in the charter that applies today versus the likelihood that the rules and court cases will change over time. And so what we recommend is that the charter simply reflect that where state or federal regulations direct CROA to make an accommodation, that we recognize that obligation which may arise at sometimes, but not to fix any specific standards because those standards will very likely change.
For the benefit of the audience, we provided a sentence that we could include in the charter, which we will look at next week in the assembly. That reflects that we can provide a reasonable accommodation. The next question was...
Pardon me. I just had a quick question. So that's in response to the Fair Housing Act.
Right. So there's a federal Fair Housing
I'm
Act.
familiar with
and
the
a
act, I
state-
just wasn't sure
Yes.
where we would go with it. I mean,
Right. So there's the Federal Fair Housing Act and an equivalent state feature, and then HUD has adopted a number of rules and regulations which guide not only property owners, but also homeowner and condominium associations on how to apply it. Those regulations tell us that the Fair Housing Act rules regarding group homes do apply to homeowners associations, so that's important to know. But those applications are interpreted by magistrates and by courts and by arbitrators, and they are always in flux. So rather than assume or adopt whatever's been written as of today, we want to make it flexible and just say that where we are required based upon our readings of the regulations and court interpretations, we will comply with that.
And the HUD one is section 504.
Right.
Okay, thanks.
You're welcome.
I'm sorry, I didn't mean to interrupt. That was good.
Yeah, thanks.
If you're ready, we'll move on. Any other questions, we'll move to question number 2. One of the issues brought before this committee was to reword the supplemental declarations regarding service areas that to name CROA as an additional interest rather than additional insured. This is more modern language because homeowners insurance companies may not recognize or add an entity as an additional insured. So what do you recommend that we do? And for those on the task force, it's tracking number 5-4.
So in answer to your question, we talked to your insurance agent, and I've talked to other insurance agents. And they identified this issue, and they recommend that providing an alternative phrasing called an additional interest as opposed to just an additional insured. I think back when your documents were originally written, they could achieve the additional insured, which sounds great. But over time, insurance policies, underwriting, and policy languages. Made it really difficult to do that. So we identified a section in the charter and in the service area supplements where we can make CROA an additional interest. And so we provided written recommendations for sections, for example, in section 5.1 of the service area supplements. They all have the same language. We provided, or in the alternative as an additional interest or a similarly described interest as may be customarily described in the insurance industry at the time the policy is issued. And that last bit is designed to address future changes in what's available so that we're getting some sort of similar protection or identification.
And I do have a specific question. You provided us with a short phrase to go into the charter, which is something that we can do easily here. But the recommendation for a similar phrase in the area supplements, service area supplements, would require approval of 75% of the owners.
Right.
That's a bigger standard because we have several service areas and they would all have to approve it at the 75% affirmative level. So let me ask you, is it worth the effort to do that? Or what if we don't change the service area supplements?
It's for every owner's benefit. Right now, each service area supplement requires them to do something that's very difficult to do. Now, CROA's general responsibility was to enforce not only the charter but the service area supplements. But we're faced with a situation where owners have a difficult, if not impossible, time complying. So it's in every owner's benefit to do it. Now, I understand that we, the committee, are focusing on amendments to the charter, but I think we should propose to each service area this amendment because they are actually able to achieve, if they can get the 75% vote, they should be able to then comply with the additional interest language. So I think it's to their benefit. And obviously, there may be other things that they want to consider, but I think we should at least present it to them and encourage them to vote on it. But you're correct. Each service area has to individually vote on it, and each service area has to get the approval of 75% of the service area members. Not 75% of everybody, but each individual service area. And it has been a challenge in the past to get that kind of approval.
Do you see a downside in the future if that doesn't get done, or if a percentage of the service areas approve it and a percentage don't approve it, just because residents may or may not be aware? Or we can attempt to educate and make them aware as best possible. Is there going to be a downside if some do and some don't?
Yeah, I consider that possibility, and in fact, that's probably what's going to happen. We're going to have some service areas that, for whatever reason, fail to make the amendment. I still think it's worth it for those that can achieve the vote to go ahead and get the vote. For those service areas that don't achieve the vote, well, they're where they are now. They're required to get the additional insured language. They may not be able to, and so if they fail, it doesn't put them in a worse position than they are today.
I understand. That's kind of what I thought. Jackson seems like he's...
Would this include Artisan Park as a service area? This something change?
Oh, would Artisan Park service area? I didn't check the Artisan Park service area to see what the language reads, how the language reads. If it reads the same, then we would want to get the vote for Artisan Park service area.
For Parkview it does, but
Right, I
not,
understand that.
right.
I'm thinking about 600 rooftops having to vote, and you get 75% is, as you know.
well,
Yeah, I don't remember what your is, I don't remember if your requirement is the same. It may not be, but I don't remember.
Could we?
because they're single-family homes, I'll look at the documents, but because they're single-family homes, I would think that,
Well, they're not, Susan. There's 300 single-family homes, and there's 300 condominiums. They're all part of
Right.
the Artisan Park service area.
certainly, certainly.
And so if the language of the supplement says 75%, I would think you need 75% of all of the residents.
Entire service area.
And that's going to be difficult to obtain. So if we could check into that, I mean, it's a good thing.
In the meantime, for the benefit of the audience and the board liaisons, we will research that as our task force to find out what language is in each one. There's about 13 service areas.
They're almost identical. The only question I have is just for Artisan Park service area, if their amendment requirement's the same.
And what I will say is, before we vote on it as task force. And we'll look at this in the future, not tonight. We're just getting the information. We can attempt to do this during this round of voting, but since this is individual service area issues, in case a percentage of them don't approve it, it can always be taken up one by one in the future as the years go by.
Right.
Okay. Anything from task force? We're going to go to question 3. Multiple questions, but it all boils down to one issue. Regarding apartment to condominium conversions, how can CROA mandate proper amount of the reserve funds prior to the condo conversion? And CROA mandate compliance with CROA covenants before the conversion? How can CROA protect itself? And do you have any suggestions regarding language that could be inserted in the charter, or how CROA can be proactive with condo conversions? It's tracking number 5-10.
Thanks.
Okay. Section 17.3 of your charter already says that the CROA board has to consent to a conversion and transfer of an apartment complex into a residential condominium within CROA's jurisdiction. And so, taking that, I drafted some proposed or suggested standards that the CROA board can use to make that decision. And this is not the end-all, be-all list, but it's everything that I tracked from the Condominium Act that is normally required of a condominium conversion developer. And that includes, for example, you only want residential condominiums. You don't want commercial or industrial condominiums under your jurisdiction. So if they propose that, you could say no. If the developer who's proposing converting the condominium and putting it under your jurisdiction fails to provide you with everything that they already have to provide to the state, it's information regarding the condition of the property, how it's going to be used, making sure the governing documents are approved and in compliance with 718, then you can say no for not turning over everything. If the exterior of the building doesn't meet your community-wide standard, I mean, you examine it and you determine, look, we have a standard here in CROA, and the building that's being proposed to be placed under a jurisdiction is on its face in violation of your community-wide standard, and that's grounds for saying no to it. We examined reserves. There are 3 requirements. There's a developer who wants to convert a condominium, an apartment into a residential condominium, has to do one of 3 things with the reserve issue, and so we identified those to make them do 2 of the 3. Fully funding reserves or establishing a bond that would fully fund for repairs to the major structural components of the building, so that when the time comes, we're not left with a residential condominium that can't fund its major repairs.
In perpetuity?
Well, at the time that the property is converted from an apartment into a residential condominium, the developer has to either fully fund the reserves or post a bond, so that when the first round of replacement or repair comes through, there is the required money there and available to go ahead and perform the repairs. Later on, the membership for each condominium, as it is now, has the right to examine their funding requirements, fully fund, or reduce, or they can vote to reduce the funding if there's a financial issue, or even waive funding, and that's within their right to do it.
Do assessments.
Yeah, so we're looking at the time that the developer proposes transferring the apartment into a residential condominium and submitting it to your approval or consent for inclusion in CROA, does it have the reserves fully funded, or does it have a bond that fully addresses all the expected reserve costs? Once it's in, and there's no, kicking it back out. It's now in. So all we're going to look at is, at the time that you are asked to consent to it, as the board's asked to consent to it, does it comply with the statute for these 2 things?
Makes sense.
Question.
Yes, sir.
How is fully funded determined?
So the statute says you have to have a reserve analysis. You're going to have an expert come in, issue a report, and then identify what the reserve number should be.
So it's based on something, not just the
Yes.
developer's opinion.
Yeah, and there's actually some formulas in the statute that identify what you're supposed to do as well. But there's going to be a reserve analysis for each one of these. I mean, you may only get one or two, I don't know. But each one of them should provide you with a report that goes to the state, and you're entitled, the board, the Crow Board would be entitled to see. And that's why I also say, hey, look, if you're not going to give this stuff to us, then we have the right to say no.
We have a substantial recommendation from the lawyer on the wording we can put into the charter. We'll look at that. We got your verbal answer. We'll look at that another night when we consider it. Any other questions? I'll move on. Question number 4. We asked legal if they could provide language regarding vehicle logos, and this is to clarify the definition of a commercial vehicle. And we were talking about logos, business or governmental type logos. I'll let you refer and tell us, what do you think?
So with your definition of commercial vehicles, I think it would be helpful to recognize that there are some standard exceptions that we should take into account or consider. So in section 7.1A of your charter, I start out by saying that if you have signage on or inside any window that displays a commercial business product or whatever, then that would be considered to convert that vehicle into a commercial use. The reason why I added or inside, it may seem like a small change. There's actually a court case where a homeowner put it inside their window, and the court said, well, it just says on, it doesn't say inside. And I pulled out my hair when I read it, and then I decided to recommend changing it. But we should recognize that, look, there are a lot of commercial identifications on your vehicle. If you drive a Ford, it says Ford, right? If you buy it from a dealer, then it's going to have the dealer's name somewhere, either on the license plate or tagged somewhere on the car. So let's recognize that. In addition, a lot of people have things on their cars like schools, universities, sports teams. You know, I'm a Dallas Cowboy fan. I might put a Dallas Cowboy fan sticker on there. So I added displaying.
APs,
Pardon me?
annual passes.
What's that?
Annual passes.
Oh, absolutely, yes. If you're an annual pass holder, a lot of people are affiliated with Disney in one way, shape, or form. We're not looking to advertise Disney. You don't get to put the website on there, the phone number to contact, you know, whatever. But if you have those little things, then we should address those. So I put, in addition, displaying the name or logo of a school, university, sports team, political, or religious affiliation shall not be considered commercial unless it is for the University of Miami. I put that to make sure everybody was awake and reading my stuff. Of course, yeah.
Can I put a period after the word commercial?
Yes.
Okay, and then delete the rest. I understand, I've done that myself, writing technical manuals.
Just want to make sure everybody's reading your stuff.
But I do like that.
Officially. Any questions or comments from task force? Okay.
I love it.
Question 5 doesn't have a counterpart in the issue sheets, but it's just a general question for interested people. Are there legal issues when considering an end to the Celebration Community Service Organization, the CCS?
Yeah, the short answer is no. It's done by the Crow Board. If there's assets left in the CCS at the time of termination, you have to address those, and you may need to talk, or the Crow Board may need to talk to the tax consultant about that. But otherwise, no.
And the short answer is it's a separate entity from Crow.
Right.
I'm going to move on to question 6. This is tracking number 6-9. According to the current charter, 7.2A, the board of directors may adopt new rules that modify, cancel, limit, or create exceptions to existing rules. And we're talking about Exhibit C in the charter, which is a list of rules which is the basis for our covenants. So the charter gives the board of directors the ability to adopt new or modify existing rules. And then the bylaws, 317F, states the board's duties shall include making and amending rules and regulations. So, Chapter 17 of the charter already requires the consent of the board of directors. Well, I'm on the wrong page.
Yeah.
Sorry. In reviewing the dozen-plus board resolutions over the last 10 years, the board passes resolutions on various subjects. And they're listed on the website under governing documents.
Right.
Some of these are policy resolutions and some are changes to existing rules, which is the case of porches, which was done,
2015?
thank you, 2015, August of 2015. So I asked legal, looking at the current list of resolutions that have impact to residents, I'm not talking about financial resolutions or policy agreements between the board of directors and CCMC, but those resolutions that impact the board, do you see any of those that should be considered by us as a task force? Which ones?
Okay, so you gave me a list of a number of rules and policies. The first one, the November 17, 2015 porches rule, you could include that as a change to your rules. The other items that you asked me about, but you didn't have to at the time. The board had the power to do it.
Yes.
But if you want to make it part of the recorded documents, then you can go ahead and do that going forward. You'd asked me about resident photo ID badge policy. That's a policy established by the board. Technology is going to change over time, making whatever you want permanent in the charter probably won't end up addressing changes in technology. So that's appropriate for the board to do and not really for the inclusion in the charter. Due dates for CROA assessments. Almost every homeowners association, including CROA, allows the board to establish the installment due dates, and it may never change, but it's nice to have the board's ability to make changes. There may be circumstances in the future that require a different installment date for whatever reason, and so it's good to leave it with the board. Access to association records. The statute changes all the time and directs us on how to handle records requests. The board that should be left to the board to adopt policies as statutes change to reflect what the state legislature wants us to do each and every year. Electronic voting. That's a new statute. It's only a few years old. There are actually administrative code rules that address electronic voting. So the board's supposed to, it's actually specifically directed to adopt electronic voting rules as opposed to including them in the bylaws. And I expect these rules to change over time. And the administrative code interpretations of these are so bare bones right now, it's almost worthless. The administrative code rules that over the next few years, I expect the Department of Business Professional Regulation to actually fill in some guidance as they encounter issues with electronic voting and they want to address it. So I will leave that with the board as well. Estoppel certificates, that's a July 1st, 2018 change where they changed a lot of the requirements of estoppel certificates. CCMC management deals with most of that. It's better to leave that with the board as opposed to including in the charter. That's the list, you guys.
Okay. Any questions from the task force? It makes sense to me. Thank you very much for
Sure.
that. I have a question here, number 7. This is tracking number 6-5. This came from, was presented to the board, to the task force as a consideration. Can limitations be placed on builders' voting rights? Depending on the date of an election, a builder could have one vote, or after a plat is recorded in the county, a builder could have hundreds of votes. This has to do with the articles of incorporation, the date for the CROA, as well as the Florida statute. I'll let you speak to that. But we were interested in how to, if this was necessary or possible or not necessary. Go ahead.
Sure. I think it's advisable. It's not required, but it's advisable to address builder voting with respect to one thing, and that's the election of directors. Because you've already had what's called turnover. You've had turnover of control of a majority of the board from your developer to your homeowners. And so anytime a builder acquires a large number of platted lots and they have the ability to exercise votes for that, that should not result in a reversal of turnover. And so the state, under section 720.307, says that once you have turnover of control to the resident owners, it should not be reversed back to the developer. It should not be reversed back to a builder or to any company whose primary purpose is to build or develop lots. It should remain with the residents. And so I think the protection is there to some degree under Chapter 720, but I think it would be helpful to guide builders when they come in to see, oh, and by the way, in case you're unclear about this, we're going to go ahead and address this in one section of your bylaws and say that each owner may cast a vote assigned to his unit, provided that owners other than the celebration company, builders, contractors, and others who purchase units for the purchase of constructing improvements thereon are entitled to elect at least a majority of the board of directors. So it always preserves to the residents the ability to elect a majority of the board, which is the intention of 720.
Is it just 720, but it's 720-307, is that the one?
Yeah, section 720.307.
307?
Yeah, so the way 720.307 reads, it
Yeah.
talks about when it applies and how it applies and to which associations it applies. And so I think borrowing the language from there to make it really clear that a builder that acquires a number of lots should not exercise their votes for a majority of the board members. Yes, Jim?
So, could we just run through some hypotheticals?
Yeah.
Since this question was raised by the land project manager of Mattamy Homes, which is the developer of Island Village. Assume that Island Village has their platted properties, 276, and they are able to vote in an election in which 4 seats of the 7 CROA members are available. Could they cast their 276 votes as a block for 3 candidates but not 4?
They could.
Yes,
Could they cast their 276 ballots for 4 members?
yes.
You mean divide them divide them
No,
up?
vote as a block and vote 4 times. They get 4 votes.
Mhm.
Can they vote for 4 directors of the 7 under the proposed language that you're suggesting?
No.
No, but they could vote for 3 directors. They could vote for 2 directors or 1 director.
Correct.
And what if they then are in an election in which only 3 seats are up? They could vote for all 3 seats because it's not a majority of the board, correct?
Yes, but, and the but is, if you have 4 one year and 3 the next year, and you voted for 3 one year, you should not vote for any the next year.
Right.
Because if you did that, then you would have elected 6 of the 7 board members.
Yeah.
That's very complicated, so let me go
That's
another
the-
direction, Tom. The way I read 720 and our bylaws, one of the last sentences in the bylaws states that the rights of the celebration company and the builders are not to be infringed on, and I can pull it up here.
Right.
And I'm worried that if we adopt your language, we would be infringing on that. I'll pull it up here.
Yeah, but it says other than Celebration Company.
Wouldn't 720 supersede it?
Well, that's a good question. The problem with the section that we're talking about is it indicates that it may not apply to associations that were created before 720.307 was adopted. The difficulty is, that's great if you hadn't turned over. It's easy to figure out if you haven't turned over because you don't have to turn over. But what if you've already turned over and have been operating with resident control for decades, and then a builder comes in and for whatever reason is able to cast votes in a sufficient number that they basically control who gets elected for 1 or 2 years before they sell
That's his
out.
proposal.
Well, that's reversing what you've already had, which is turnover. And so, the purpose of this proposal is to reflect how you are now, which is that the residents control the association. And it's a valid question to bring up, which is, well, if we're gonna make this change, does that impair or infringe upon the rights of TCC or the builders? Well, let's start with TCC, all right? They have some rights to say yes or no to amendments anyway.
Right.
So their consent to this amendment solves whether or not they're okay with this change. And then the question then is, okay, well, if TCC consents, do builders have some additional consent or veto rights over these changes? And the answer is generally no. If anybody feels like this is an infringement on the builders, my point is, it's the only way that this affects builders is if they exercise their voting rights to reverse turnover. And then I think you can go back and say, well, what's the intent of the statute, and what's the intent of preserving turnover within your association? And does that supersede whatever the builder wants to say with respect to their election rights? They're allowed to vote for anything else. They can vote for or against any amendment that they want to. This is only about elections, and it's only about choosing a majority of the board as opposed to no more than 3 members of the board. So it's the only issue we're dealing
Well,
with.
that's a good point, that if they're okay with this amendment, then TCC would be accepting that the builders' rights have changed. I understand that.
Right.
I apologize not being prepared. There is a sentence in the bylaws that said, any amendment cannot infringe on the current rights of TCC, and they specifically say, and the builder.
Right.
And I'm afraid by telling the builder he doesn't have a vote, or they can't vote for the majority, that would be contrary to their current ability, because the charter and bylaws say that the builder has the same rights as an owner, period.
Right, except where the statute and the intent comes in for preserving turnover. Now, you're right, it's something that has to be addressed. And the question is, what's the builder's options? Well, builder option number 1 is to vote against the amendment if they want to vote against it. And then if it prevails, does that mean that when we approach them and say, look, based upon these bylaws, you're free to elect up to 3 of the 7 board members in any 2-year period? If that's a problem for them, then we have to address it at that point. And it becomes a, just so you understand the mechanism for it, if somebody says, hey, they did the wrong thing, or they say we did the wrong thing to them, we prevent them from voting, then what essentially happens is there's a petition for election arbitration, and an arbitrator from the DBPR tells us if we were right or wrong about it, and says if it's enforceable or not.
Well, this got the conversation started. I'll get into it more deeply at a later time. But to set the record straight, this was not brought up by the land developer of Mattamy Homes. This was an issue that was brought up by the board as one of the 3 pages of items they wanted us to look at. What I did was independently ask the builder when they expected to have a plat. And that's what you're reading in the issue sheets, is just his generic answer on when they think they're gonna have a plat, which would then give them X number of votes.
Yeah, and the date of the plating becomes really important,
Right.
because if the plating occurs prior to the vote on the charter,
Yes,
then under the existing charter, they would have votes,
one
correct?
vote per parcel of land.
Right, that's platted, right, so 270.
Oh, no, I apologize, I misunderstood. Before they plat, they get 1 vote per parcel of land, which is a unit, which is the same as a homeowner,
Right.
which it could be at most probably about 5 parcels of land they own in that vicinity.
Prior to plating.
Prior to plating.
Yeah.
After plating, which means it's recorded by the county, then they have as many votes as single-family homes, which is 276 in phase 1.
Right. So my point, Gary, is that if that process were to occur prior to January 1st, 2020,
Or the end of voting.
right, they would have the ability to vote on the charter amendment, which would impact their right if this amendment were made. And so that date of plating becomes really critical. If they miss the 2020, the beginning of 2020, and we've gone through our vote, and we've had our board of directors election, and now they plat, let's say, in April of 2020. They are now bound by the charter and the rules as they exist. So we have an interesting circumstance here in which there is going to be some incentive for the builder to have the platting finished and approved. And then the question that I've got is the platting approved at the point that the county records the deed? I assume that's the moment.
That's
right?
what it says in the charter.
Yeah, so once the plat is recorded in the public records,
Right,
that's when it takes
okay.
effect.
So there are different levels of approval, CCDD, ECDD, CROA, kind of.
But the charter is very specific,
Yeah.
recorded in the county that
Okay.
day.
So I just want everybody to be clear that this could be something that is proposed, voted on, and put into the, not voted on, but put into the charter changes that could attract significant attention from one particular voter who has 277 votes.
I don't want this to be a one-time consideration. Yes, it may or may not impact this particular vote, but as Island Village, and let's look 30 years out, if they decide to develop the land on the other side of I-4, this will come up every time a plat is recorded in the future. So it's not something we should just consider, oh, we missed that one.
Right.
It's gonna happen again.
Yeah, but, the language that I'm proposing is really clear in saying, no, the residents will always be able to elect a majority of the board, so that anyone who buys in here understands that that's preserved, provided it gets approved.
I understand. I was concerned about, of course, the dates, which is very specific in Florida, 7/23/07.
You're right about that.
It doesn't pertain to associations that were in existence prior to 1995, and CROA was in existence prior to that date. So
Right.
it doesn't pertain.
You're right.
So I'm worried about probable legal
So,
implication.
not to go too far into it, but every case that addresses the when does it apply or who does it apply to question is addressing an issue where a developer has maintained control of the association's board
Yes.
far longer than residents have
Yes.
felt comfortable. There's no case where you've had turnover and then a builder has stepped in and retaken control, and the courts have said, well, in that case, this is the answer to that question. So we have an unanswered
Untested.
question in this circumstance.
It's untested.
Yeah, if it, like I said before, if the developer had retained control, I would say, well, then, okay, that's what we're left with.
Of course, the developer doesn't control, we're on our own.
Right,
But the builder has rights as defined in the charter and bylaws,
correct.
which pertain directly to when the CROA was established as opposed to section 72307 Florida statutes.
Right.
So I agree, it's untested.
And just some clarification. If I'm reading everything correctly, once it's platted, he can vote the 276 plots,
Right,
whether or not he builds.
right.
Yes.
So if we were coming into a real estate crunch like 2008, and it would look like Osceola looked for the last 10 years, with all that platted land, but no houses on it.
Right.
So he'd be representing himself alone.
Yeah, if he owns those 276 lots, he can vote and represent those 276 lots.
And of course, the corollary is true, the same with Spring Lake. As the lots are built and sold to individuals, they now are the owner of the unit. They have a vote, and the builder has less votes as they sell off their property.
Correct.
Okay, we'll end that discussion and pick it up later. It's question 8 now. This is tracking number 611. The bylaws 6.6A state the celebration company may unilaterally amend bylaws for any other purpose, provided the amendment has no material adverse effect upon any right of any owner. is that in conflict with Florida statute 720-3075-1A, which prohibits this language after transition of an HOA control to the membership?
Yeah, that's kind of related to what we just talked about.
Yeah.
There's a public policy statement in Chapter 720. It's helpful to us. It basically says that as a matter of public policy, Florida doesn't want to allow developers to go back and unilaterally amend documents after they relinquish control of the association. So there's a statement. But again, we're talking about a statement that was adopted after Crow was created. And so there's also a general rule that says you don't retroactively apply statute changes to pre-existing corporations and homeowners associations. So with that, the answer to your question, and this is the lawyerly answer, is I'm not sure. I don't know. No one's ever tested that. It's very unusual for a developer who's not in control of an association to simply unilaterally amend things, although it does happen once in a while.
That's a good point. Since control has been passed to Crow, the developer in general has relinquished that control. But unfortunately, our bylaws are very explicit.
Yeah,
They state that he does have the opportunity without exception.
it does. If that does occur, if that did happen, there is at least a reasonableness test. The courts will examine the change, the proposed change, to make sure it's reasonable, it's within what's called the common plan and scheme of your community. That doesn't make such a big difference in how you operate or how you develop, that anyone coming in would say, wait a second, this is not the community that we were sold or that I expected.
For the audience, the reason we brought up these very difficult questions was, other than the membership, CROA, voting on one amendment in 2015 that had to do with capital assessments, this will be the first vote of the entire membership on charter changes. The previous charter revision of 2010 was done by representative voting, which was different and has been changed. This will be the first time the entire community will have an opportunity to vote, and that's why it makes a difference here. How many votes are we talking about? And that's what we're talking about. We'll dig into this more later, but thank you for looking into it and it bringing it, you might say, to our attention so we can discuss it in the future.
Sure.
Does the task force have any other questions they'd like to ask? That's the end of that little piece of agenda. Anything else? I will say we will generate another list of topics to discuss over the next few weeks, and we'll send that to you for future reference in about a month.
Sure, happy to help.
Okay.
Yes, board.
I just want to clarify, action item 6-12 having to do with removal of a director. We do have, Charlie Elbridge from your office wrote an opinion around that. Did you want to discuss that, Gary, or no?
I didn't want to surprise legal counsel with something that we didn't tell him that we were
I'm
going to
familiar with it.
discuss.
He's good on it.
But if he's willing, let me read the issue for the audience.
You're welcome.
Sorry, Tom.
No, it's okay.
Okay. The bylaws state, excuse me, we're talking about 611 or 612?
612.
Oh, excuse me, okay. In the bylaws, 3.5, it speaks about removal of a director by the board of directors, not by the membership, but the board of directors being able to remove a director. And there is some case law. One of your colleagues provided us with some a legal opinion. I'll let you go from there.
Oh, sure. So your bylaws say one thing and the statute says another thing. Your bylaws say that the board can remove a director if that director is more than 30 days delinquent in the payment of any obligation to the association. Chapter 720 says that a director is automatically removed from the board if they're more than 90 days delinquent in any monetary obligation to the association. So the obvious question is, well, which one rules? Is it the 30-day or the 90-day? There are cases and arbitration decisions that tell us that the exclusive method for eligibility and removal of directors is within the statute, the exclusive method. And so let me explain what that means. I have associations where it says if you miss 3 meetings without excuse, you're off the board. I have, if you file a lawsuit against the association while you're on the board, you're off the board. And many other little things that a lot of other corporations, Chapter 617, not-for-profit corporations, clubs and things like that have. But when 720 was amended to say everyone's eligible to be on the board, except for people who are more than 90 days delinquent or have committed a felony, have been convicted of a felony, and haven't had their civil rights restored, the state was basically saying, that's pretty much it. Those are the only 2 grounds for removing directors. And so all the cases and arbitration cases, decisions have gone that direction to say, no, you don't look at your shorter, easier, laxer term bylaws or articles. Now you only do what the statute says you can do. And so they use the words exclusive because they want to be clear that the only way that a director is removed is if they're more than 90 days delinquent, if they've committed if they've been convicted of the felony, if they've been charged in court with embezzlement of theft from the association, things like that.
So if I may summarize and tell me if I'm right, the short answer is our CROA bylaws allow our own board to remove a director on the board, which is in violation or contrary to Florida state statute. So our resolution is to remove that sentence which allows the board to remove a member. But the membership can always remove a board member. Would that be fair?
That's correct. A majority, even if a board member's been elected, a majority of the total voting interest of CROA can vote to remove, basically called a recall a director from the board, and then depending on how many board members are recalled, either the board or the membership will choose replacements.
Right. Now, all I wanted to summarize is we'd be removing a sentence in the bylaws which would be in conflict with Florida statute. So it's an easy fix.
Right, it's easy.
Yeah, okay.
And what we should do so that nobody's confused in the future.
Sure. Any other questions before we dismiss the legal opinion? Or not? Okay.
Anything else? All right, well,
Thank
thank you
you.
very much. Always good to see you guys. And,
Yeah.
look forward to your next set of questions.
All right. I appreciate your patience in the audience. I wanted you to hear that because it's somewhat interesting when you talk to people sleep. But in a public meeting, we always have room for public comment. So now I'm going to ask before we continue, is there any in the audience which would like to speak, have a public comment for the task force?
Or through you?
Any issue or comment from the audience? Seeing none, we'll continue on with our next agenda item, which is the Covenants Committee inputs to the task force as we review the charter and bylaws. To reference, there are 2 committees called out specifically in the charter and the bylaws, and that is the Covenants Committee and the ARC. And we've asked those 2 committees to get together and look at the documents as a whole and tell us if there's something that the committees, which is made up of owners like ourselves, volunteers, that they would propose that we consider for changing the charter and the bylaws. In addition, we also asked the Technology Committee because they just formed and it's of interest, which is one of the founding pillars. So we now have the chairman of the Covenants Committee, Steve Kleinfelder, and I want to say thank you for the work that your committee has done to provide us this. For the task force, we originally received the input on the 21st of June. They've since made a few updates and revisions and clarifications that we got this week. Your version 8 is still valid for issue sheets. And what I'm going to show you is the charter, and just this week, I updated their comments on the electronic screen of the charter, which is on the right. So this reflects your update.
Okay.
However, to help us along, the Governance Committee has provided us with an electronic version of their input, which will be on the left screen, and that's easy to read too. So I'll turn it over to you, sir, to present what you would like to tell us.
Okay, good evening and aloha. So, my name is Stephen Fromfelder. I am the chair. I'm trying to be gender neutral because I have some very great members of our committee that have participated, and they bring a significant view to how we see and address our community. This was a review of, as Gary had said, of the base document of the 2003, and from there we started to go. The purpose of why we've brought this and I've created this presentation is for a little bit of clarity, try to move it through so that it's not just looking at words on the screen. So we'll go from here. The background and source information of what we had done as a committee for recommended changes, additions, and deletion are again from the base document that was provided to us as the 2003 charter. And we also looked at other locations that are homeowner associations, such as Babcock Ranch here in Florida, which is a CCMC managed community also, and Harmony, Florida, and we looked at some other locations. Everything that has been presented here was also provided to and through the committee. It's been discussed, and so they provided review and comment of what was submitted on the 21st, and we've made some adjustments from there. Bottom line up front, this is to provide clarification, specificity of the review by the committee, the Covenants Committee, and these are the general topics of which I'll be going over. Structure of the Architectural Review Committee, compliance and enforcement, expansion and clarification of Exhibit C, which is primarily in the restricted activities and prohibited conditions, and then in Exhibit E, which is the bylaws of the Celebration Resident Owners Association. At any time, if anybody has a comment, question, or whatever, please feel free to interrupt me. I have no issues with that. This is not for me just to push it through, but this is a dialogue, and we'd like to get this as much as possible. The ARC is our companion committee. They make up the standards department that we work through with CCMC or Town Hall. So they are an equal mechanism to how we maintain our community. And with that, currently it reads that ARC consists of 3, but not more than 5 persons who serve and be removed at the place of the board's discretion. What we are recommending is that the committee member that number should be increased to not more than 7 members. The rationale is that the number of personnel that are on the Covenants Committee is 7, so it should be an equal part in participation. And so that's one of our recommendations.
Can I stop you here?
Yes.
If we may, for the task force, I would like to consider each of these individually. I think they're very straightforward when you read them. And of course, you've had this for the better part of 3 weeks. And tonight, this is our agenda. I would like to get a vote, consensus from the task force on each one. So we can look at each one, discuss it, and say yes, no, or modify it because we have that ability. And I want to do it tonight because if we delay this any longer, it just creates more work down the road. Because we have a lot more to get through before November. Is that okay? Sound good? All right.
Are you ready for that?
I am 90% ready for that. There is areas which will be for discussion, and we will probably have to go back and reattack. But I think in general terms, I think that the committee's recommendations are those of which we should proceed through.
I forgot to mention at the outset, for full disclosure, I am a member of the Covenants Committee, one of the volunteers, residents of the committee. I have no part nor participated in this work that they produced. So I'm seeing it as a member of the task force, and it didn't construct it.
That was the non-attribution part.
Do you have anything to add on this first change, which is, if you look, ladies and gentlemen, at the, on the right screen, this is the charter. It involves changing the word at least 3, but not more than 5, to 7 personnel. And I'll admit that that is, the number 7 is how many people are on the covenants committee, so we're making the ARC committee the same.
Mhm.
That way they have more people, so if people are on travel or sick, they can still form a quorum and conduct business. Do you have anything to add?
Not on that particular item, no.
right.
I have no
wanna take
issue with that.
One by one.
Yeah, it's fine.
Any discussion with that?
I think so.
Logical move.
No?
I'm good.
Yay?
Yay.
All those in favor?
Mhm.
All right. Any opposed? We will accept that, and will be reflected in our issue sheets next time. We'll do each one, so.
That's fine. It's going to be a long night, I'm sorry.
No, we'll go,
We're quick.
yeah.
Okay, the next item down here is that the ARC members that we're talking about, ARC members not be owners or representatives of owners. We recommend that if you're going to be on any of these committees, specifically covenants or the ARC, that you must be a member. Not somebody who's you got to have skin in the game, you need to be a participant.
Who would they be if they're not owners?
They've been renters before. They've been-
We have a renter right now on the ARC committee, and we have 4 members. We don't have 5 members at this point in time.
So there's 4 and 1 is a renter.
No, there's 4, and one of those 4 is a renter. We do not have a 5th.
Got it.
There's a reason for
Do you need help
No,
with,
no.
I can help with a little bit with that if you'd like.
Go ahead.
Part of the challenge is getting expertise with regards to architecture and
Right.
engineering. It is a challenge to, as you can see, we don't even have 5.
Right.
If you were to make the change, obviously, we'll make it happen. But that's the reason and the rationale is in order to make sure that we have the qualified individuals. For instance, we have people from Disney that's their expertise. And we have one of them that is actually from Disney that is on the board and has actually said, if you need more people on the committee, I can reach out to Disney. So that's one of the things that we've been using in the past as a resource.
Well, that leads into, just so I can go into the next one down, there has been discussion through the community that particular line that says that it should be an architect, an engineer, or a similar professional is no longer, as I say down here, a requirement. This is a well-developed and mature community, and at this particular thing has been used as a discriminator to where the feelings that I have been portrayed to me through into the Covenants Committee is it's not balanced, it is not with fair representation, and so that's why I'm recommending, or we are recommending, because we are made up of volunteers with no qualifications, other than that we're owners, and that it should be that of the same thing. It should be owners, and it should be that there is no discrimination.
Well,
Is this the view of the ARC committee or the?
No,
Covenants
that's the
committee?
view of the Covenants Committee.
I'm going to disagree with that personally, and I think the only reason I would disagree with that is because I think if you deteriorate some element of expertise, of structure and architecture and integrity, I think it says the ARC may, but not need, include. Doesn't have to, but I think there's a logic to having some,
No, not necessarily. Pepto-Bismol paint?
I would like to,
I think it's a very unique
Seafoam
community
green.
that started with, yeah, but is it more than that, though? You know, I mean, are we?
It's a lot more than
Yeah,
that.
I mean, I think it's more than just whether I have plastic plants on my front porch.
Agreed.
You know, so I think there is I think, I'm not an expert on certain architectural things. I would think if we could get that expertise, it would behoove us to do that.
if I may, these issues are related, but they're 2 separate issues. So I'd like to go back to the first issue, which is, do we want membership to be owners only, or allow non-owners to be members of committees? Now, I'd like to invite your attention to tracking number 2-2. Please turn to that. This was brought before a working group on the 28th of May, It has not been brought to the task force until tonight because we were waiting for the Covenants Committee. If you're looking at 2-2, we had a legal opinion from Tom Slayton on the 12th of June, who said committees can be limited to members if you choose,
If you choose. okay.
owners only. So, I'm saying we have to, but there. I'd like to consider that first before we go into the makeup of the committees, of talent.
Can I ask a question
Yes.
just procedurally?
Sure.
I'm confused about why Covenants is proposing changes to ARC or to committees in general. It seems to me this is a bit of an overreach. Am I missing something? Was the charge to Covenants to
Well, the charge
look
was
at
to
all
look-
committees, including ARC?
We were charged to look at the entire document. And
We're
then
charged to look at the whole document, not just the Covenants part of the
the
document?
entire document.
Yes, but it is related to that. I can't speak for Michael, the chairman of the ARC, but they're interested in having more members. I'll let
Well, I'd
him
like to
speak
hear
for
from
himself.
Michael
Sure.
about this. This is just me as a liaison, so you all decide, do what you want to do. I'm uncomfortable with any committee choosing to tell other committees or to look at the whole document in a way that seems expansive. And I appreciate your expertise, but your expertise is in Covenants. It's not in ARC or in committee membership. I mean, the rule that you're talking about would affect the Recreation Committee. Is that your intention?
No, it's not my intention. I had not mentioned anything about any other committee except for ARC.
It's only for ARC specifically.
Well, but I'm looking at 2-2, which is committee membership that you just raised.
That's right.
And so it's got implications for that.
I have no knowledge of that. All I am saying is that that committee, be it the Architectural Review Committee, mirrors, or we mirror them, because it is the Standards Department of which the fact that the two work hand in glove. Actions that the ARC committee does is either a denial, an approval, or whatever,
Right.
and then are not enacted, then come to the Covenants Committee
It is,
as for enforcement or violations.
it is true that Stephen is only talking about his input for a particular committee and its ARC. I'm only pointing out to the task force that this has been considered as a general category, working group, and we've already got a legal opinion on all committees. I just wanted to point that out as reference information. Now, going back to ARC, if the committee would rather hear from ARC directly, we can postpone this particular item.
I'd like to find out what
I'm actually-
Mike's thinking is.
I'm the ARC liaison too, so if there's any specific questions.
Dan, can I ask you a question? If the person that's from Disney, does that person live in Celebration, or is that person just an
The one we have
engineer
right now
from
lives
Disney?
in Celebration.
So he is a member of Celebration? Or
And
is he?
I believe he owns in Celebration. I don't think he's a writer. I think he owns here.
Okay, so it's not like he's an engineer from there that comes over here for the meetings?
No, he happens to be he happens to work at Disney, and that is his expertise. He happens to live here.
I think I concur that I feel a little uncomfortable with not having ARC here. And I'm innocently ignorant, that's why I'm sitting on this group, because I'm just asking questions going, is there even a problem? Why are we even talking about it, quite honestly? And, I do think there could be, it's something that really we should think about. There could be value. I mean, if we just have only owners, I mean, does it get myopic? Does it get groupthink? I mean, the diversity of thought can be a very positive thing. If we only have 4 members and we need 7, what makes us think we're going to get 7 community members? So I just think it would be, I would want to hear from ARC to say, what are the issues and challenges, and why are we limiting it just to, so we're saying we don't think we need the expertise. All right, I want ARC,
Right.
what are their thoughts on that?
There's nothing wrong with your input. Thank you
No,
very much.
yeah.
They were directed to look at.
Okay.
And to match up the committees. That's fine. It's an input.
So this is the covenant's opinion of ARC?
Yes, this
Okay.
is just an input.
Right.
But if the task force, the 4 of us feel like we can postpone this for another meeting and hear directly from ARC, and I have talked to the ARC chairman about his input, we just haven't.
I think so.
We
My 2
could,
cents.
I'm fine with that.
Michael just got back from vacation, he was gone for
Right.
6 weeks, so. he just got back.
Yeah, I don't see any, I think the second one is easy enough to,
Postpone?
as long as you can staff, not staff, but get 7 volunteers, which if there's only 4 out of 5 now, maybe getting 7 becomes problematic. But I would like to hear their opinion on the last one, because
Sure.
I'm not an architect and engineer or any of those, but I've been involved in construction and certainly have the vocabulary to discuss these issues. So
I would think you would
the
want that
question is whether they
expertise.
feel they need the expertise.
Yeah.
I'm going to ask that we table these 3, although they're excellent
That's fine.
inputs. And we'll get ARC chairman to discuss it. We're just tabling it, nothing wrong with it. So we're moving to your next item, which is chapter 8. Is that correct?
That's correct.
Okay, and then scroll down to chapter 8. And this is, yes.
Hey, Gary. Can I make one quick comment?
Sure.
I think it's important that everybody know that I'm a member of the Covenants Committee, that everybody knows that even though we've had the opportunity to weigh in on the entire charter, some of us did just concentrate on not only mentioning changes to possible covenants, and even though I agree with almost all of what Steve is going to put forward tonight, we didn't vote on it. The entire committee did not vote on this, so I just want to make sure that everybody is clear that this doesn't necessarily represent the opinion of the entire Covenants Committee.
Fair. Sorry, that's fair. We're all owners
Yep.
and residents of Celebration, and we all volunteer.
Mhm.
But that's fine. Let's move to something more in your purview, which is chapter 8, the compliance with covenants and standards, and that's on your slide now.
Again, this is the idea is to provide some specificity and to give some examples that then we would list into this thing. So I'll let you read the first part of this thing as to where it gives some definition, because as that we deal with hearings, as that we have issues of where the owner or a renter or somebody who has come in here has difficulty understanding what it is the inspector has provided as that they have listed as a violation. There's an issue of either cleaning, painting, or whatever. So for inspection purposes, what we're trying to define is within 6 categories, and the examples are the following. Yes, sir.
This is new language.
This is new language.
Okay.
Everything that's in blue is new language.
Can we take it one paragraph at a time?
Sure.
So I'm looking at the first paragraph, which community standards apply to all site work, which I've typed in here so people can see where it sits in the charter. But I do have a question. According to your slide, it appears this chapter 5.1 is
I may have
where-
gotten it out of order. yeah.
It's just where it came from, but it's not part of the wording you want here. Is it?
It should, visible structure, I may have
Period
missed.
After the word structure?
Yes, just a period after.
Okay.
I
But,
pulled from the wrong place.
It appears that this language came from chapter 5.1.
Right.
So your recommendation is to reprint it in another section of the charter?
Yes.
Just, that's my observation. Let's read this paragraph.
Steve, go ahead.
But the community standards will apply at all site work, painting, landscaping, structures, improvements, and other items placed on a unit in a manner or location visible from the outside of any existing structures on the unit, as well as modifications to the interior, screened porches, patios, or any other portion of the structure visible from the outside of the structure, period.
So lifting it from 5.1, placing it into compliance paragraph here, apparently you're reinforcing that compliance applies to all the following.
Yes.
Discussion?
Nope. And the 6.
No? Pardon?
And then
Oh, that's a
the
separate
next.
issue.
Oh.
That's the next paragraph. I'm looking at one at a time, so we don't,
Mhm.
I don't know,
You got it?
you know.
I'm good.
Well, my issue is, it already exists in the charter.
Right.
Do you feel like it's necessary to republish it in another section?
Well, compliance and enforcement, I think it's nice to have up front that this is what we're looking for.
I don't know if we need it twice, do we?
That's another
It might
question.
get removed.
I'm being very pragmatic,
Mhm.
and my knowledge of the charter is, I've read the thing, so I
I
know
think
what
it's
it's
gonna
been
get
said. Now, other people have said the charter is confusing to me because they don't know what chapter to go to find what they want. Sometimes it is good to refresh our memory when we're opening the page that applies to us. That's okay. But I'm asking the question. If you want, check chapter 5.1, you have it on paper.
Yeah.
And
So
then-
it would create an issue that if you changed it in one paragraph, now you have to go change it in another paragraph,
Well, that's kind of what we're doing this year. anyway.
versus just having one paragraph where it says.
I know, but that's kind of what we're doing now.
We're deleting it out of
There's a lot of things.
We're deleting it, so it's only going to be written in one spot.
No, we're
No, no,
duplicating it.
I'm trying to understand what the
Duplicating
question
it.
is, I guess I don't
No, we're
understand.
not duplicating it. That wasn't your recommendation.
My
What are we
recommendation
asking?
is that it's referenced as in, it would be referenced as chapter 5.1, and that's where it's drawn from. And this
Right.
then becomes an expansion of that in compliance and enforcement. It
Is
gives
it
it,
missing
So
a-
just, so I think what you're doing is you're just saying, you're putting it in chapter 8, but you're referencing it, the original source is 5.1.
yes.
Okay.
And this then expands, be it the next paragraph, that's how it leads into this
Okay.
thing.
That's-
Expands into what these categories are.
That's a separate issue. It is related, but it's the next paragraph.
But it's a continuation of what you're saying.
Yes.
It's not a separate issue, it's, okay.
All right.
It's not a separate issue. It
Yes, okay,
continues forward.
I see what you're saying.
So now that you see where it came from and knowing that it's going to appear in the charter twice, now the second issue is an expansion. Go ahead.
Yes, for inspection purposes, community standards have been defined in 6 categories. Examples follow, but they are not all inclusive. Those examples are listed up on the chart now. There's nothing that currently in the charter that specifically lays these out.
Where this comes from is a board resolution, and at the end of 2014, when the board categorized violations in 6 categories for fining purposes, so that people wouldn't be fined for plants, mulch, landscape screening, and pavers individually. They would be fined in one category called landscape. So you could receive a maximum of 6 categories of fines, not 27 fines, because you have 27 plants missing, if you know what I mean.
And does that, what you just described, is that laid out somewhere in the document
No.
here? That's only the board resolution.
It's only the board resolution.
So if the board chose to revisit that, changing categories or changing fines, they could do so. So this is for example purposes only, you said, and not inclusive.
No, it's not inclusive.
So why
Because
do
it
we
can
need it in the
change.
charter, is my question.
Well, that's a good question.
If we've got it over here, I think that's one of the things I'm learning, less is more in the charter. Why do we need this in the charter if we've got
Right.
that over there?
Some, related to that, Kathy, is even though these are examples and the charter has language, it says, but not limited to,
Yeah,
the board or covenants committee can rearrange all these definitions of the 6 categories anytime. So that under cleaning, it could be reduced or added to, and the charter would sit there unmodified for quite a while. If the board.
if this wasn't in the charter.
If it was in the charter, it would be like this, but the covenants committee and the board could change these definitions at any time, and then the charter would be slightly incorrect.
So that's my point. Why would we want the charter to be, why is it necessary for this to be in the charter? That's my question. If we've got it somewhere else, why does it need to be in the charter? That's the question I'm asking.
Where is it?
It's a
Where
pol-
else is it?
It's a policy statement.
That's the point. It is only a policy statement,
So it's not.
We are
It can be
trying-
changed by a board,
Yeah.
by the
which
board.
could be changed by a board at any given year. And the issue with this is that with aging community, trying to establish that then this is established in a paragraph, and it's in the base document, be it the charter, these are what we would like to establish as, this is the beginning standard. It can be modified by policy, but this then becomes the foundation.
As you heard the lawyer speak a few minutes ago, for instance, the access to association records, there's a two-page policy on how a resident can get access to association records by submitting a written request and outlining what they want, and then they produce it, and there's man-hours involved, and you can only do it during working hours. There's a lot of little policy statements. This might be considered policy rather than a rule. I'm just offering all sides of the argument.
Okay. On the landscape, it says lawn art. Are we talking about somebody's cute little frog that's jumping across the yard?
I don't know that.
What are we talking about?
I don't know.
Laura?
What are we talking about?
If you're going to talk, come up here to the microphone. Laura is our community standards manager, for those of you who aren't aware.
And the reason I'm asking is because I walk my dog around the neighborhood and I see a lot of lawn art that's just barely on the edge of being acceptable, but people want to put the little windmills in their garden, or they want to put the turtles in the garden, or right there on the grass. And so, but I'm hearing from the committees that that's not accepted. But you're saying that this has been here since 2003, so this is lawn art. Is it 2003? Not? So this is new? Is this new? So.
I don't know the exact time that this was put into place. It's been there for a few years. But as far as yard art specifically, unless it is not holiday specific and it's anywhere in a landscape bed or in the yard, they are required to get approval for it. Because there are rules and regulations as to how tall it can be, how big it is, that type of
So
thing.
it's not prohibited, you just have to get approval.
Correct. You just have to submit the application and get approval.
So the pavers that suddenly look like Mickey Mouse,
Would be considered yard art.
all right.
So it's all applicable to be approved, you just have to put in an application to be within the design guidelines. This is not a prohibition, these are categories of violations if it's out of scope of the design guidelines.
So we need a covenant related to good taste.
Yeah, that's my, where does it end, you know, seriously? I mean, you know, I mean,
Too late for that.
let's lighten it up, you know?
It's
and-
this now.
I know, but that's my point. Again, the more we put in that charter, the next thing you know, you're gonna be looking at it. I mean, I guess I am okay with a CROA board needing to flex this from time to time. If we look at it and go, that's ridiculous, that somebody's gonna come out and measure a piece of lawn art. You know, I'm just saying, the more you put in that charter, the more bound you are to that. And I'm
I have a compromise.
not necessarily comfortable with
Bill
that.
hasn't said anything yet, I don't know, but.
I don't have any lawn art either,
The
just for the
compromise
record.
is, if you don't put in the specificity, which could change over time and then cause us legal issues, or at least appeal issues, we could say something to the, and I'm not 100% sure, say, for inspection purposes, community standards haven't been defined into specific categories as outlined in current community standards policy. Don't list how many categories, or don't say which ones they are, just say they have been defined in specific categories and leave it at that. Or don't say anything at all.
having been a new owner at one time, all of this stuff I heard about through the rumor mill, there was nowhere to look, so I think there's some value to this.
Yeah.
And again, it's like, where do we put it? And as long as this is highlighted as typical, but not binding, so that there's flexibility.
To tell you the truth, all of this is in the current design guidelines. There's, what, about 24 design guidelines
At
in
least.
Celebration? And they're all approved by the board and written by the board and ARC with Covenants Hill. So in one way or the other, all of this is covered. It's in the design guidelines.
But all
But
of
does that
that,
package go out to new buyers?
It's online. You can see it under
Yeah,
covenant
so I don't
documents.
know if it needs to be in the charter.
but the issue with what we're trying to do with this is the fact that it brings it in to the base document. It lists it in a very quick and easy way, instead of having to hunt through every design guideline, every one of the, look for the base document, now go to all the policy statements, now go to the design guidelines. This gives you at least a first brief location that it's in the base document, and then from there, if you want to go for further specificity, that's what the policy will allow to change, and allow you to get into more definite and detail. This is just supposed to be a quick reference, so that we can go to this chapter and, and cite it, versus as what we have to do in some hearings, is that we're going through 3 documents that have to lead through, that it violates to whatever, because there's not an overarching,
If that's the intent, when we play
yeah.
the lawyer, is having this specificity in the charter only tells me that these items are looked upon as I need to be in compliance. But in order for me to find out what that compliance is, I still have to go to the documents.
But you still,
Maybe we could create a new document that's simple for people to understand and use, that includes key pieces of information versus, and again, I don't necessarily think the charter is an easy reference. I didn't even know there was a charter until, So I mean, I'm, again, very innocent later on going in, I mean, a lot of homeowners have no clue of any of this, so maybe we need to simplify what we provide homeowners versus
But that's what
putting it in a legal document for 10
Well,
years.
This is not to define what you have to be in compliance with. That is pages of height, colors, sound, design guidelines are very
Right,
specific.
right.
Can't put that in here. What I see the intent is they wanted to show people that you have to be in compliance, and here are some of the issues. The question is, how detailed do we want to tell people that the charter requires you to be in compliance with covenants, period, which it already says.
So if it already says it, why do we need it in the
Well, it
charter?
already says you have to be in compliance with
Yeah,
the design guidelines
Right.
and covenants,
okay.
but that's all it says.
But there's a policy that tells me this,
Oh,
correct?
yeah, it's called the design guidelines.
Right.
It's online,
Just
and you can get a copy.
Trying to keep the charter,
Gary, quick question, Tom Slayton has given kind of some overall sweeping advice with regards to this, with other issues. And it's basically has been, you don't want to make big changes to the guideline, or to the charter, because it's permanent, you have to, again,
Right.
go back to vote. So I think just as you're evaluating the changes, I'm thinking back to what Tom had said during the both meetings, keeping things simple.
I will give you a extension of that, if I may, and I'm just speaking as a member of the task force, not trying to persuade, but all of us are trying to persuade each other, is at some point, some changes will be viewed by the population of Celebration as being what? And they're gonna wanna know, what is this about lawn art? And they're gonna be reluctant to vote on this if it's in the
I
charter,
totally
because they
agree
don't
with
understand
that.
it.
That's right.
And I'm afraid that could jeopardize our whole
I
intent of looking
concur.
at the charter.
Yeah, I would echo that, Gary. I think that's wise. At the end of the day, you have an administrative task, but we as the board have a political task, and the political task is to take your recommendations and make them palatable enough that a majority of voters will approve them. These are perfectly rational, reasonable things. However, the more perfectly rational, reasonable things we do that lead into pages and pages and pages and pages, the more we run the risk that we will make this so difficult that it's difficult to get approval. And so as you, as a task force, have to make your decisions about what to do, there's nothing wrong with anything that's written in this section, in my mind, at all.
I agree.
But it's duplicative and it adds to the complexity,
Right.
as you said. And therefore, it may be the better part of wisdom to just be referencing it without having to put it all in, so that we don't have to drag ourselves through the minutia of this.
Well, that's why I said that even though these are related, paragraph 1 is one consideration for the charter. The second paragraph, which has 6 bullets in it, is a whole other consideration. And I'd like to look at those separately, when they're related. What do you think about, do I add one, do I add the other, do I add both to the charter?
Well, I think you're going to have a much easier sell on page 4 than you are on page 5.
Well, you know,
This feels like the technology committee, you know, the whole conversation with technology, right?
This is, here's a possible compromise. Or we submit, not for purpose of the standards or whatever, we cite a reference. Where do you find it? Where do you find, is it on a website, is it posted, or whatever? All that we're trying to do is to,
Provided we keep it there. We got
Well,
10 years. You know, God
I
knows
understand it.
where we are in
What
10
we're-
years. It could be,
part of the
a chip
committee's
on my arm.
objective is to help town hall do its function and for us to have the homeowners meet the standards and maintain the standards. That's all that's what the committee's intent is. And so if that last, the third line down is, and those standards can be found at this particular area, I'm fine with that, okay. So
I think there's other ways we could help the community that has nothing to do with this, that we could help town hall say, what are easy documents that you could provide me that are going to tell me what the rules and regulations are and things like that?
Celebration News has a monthly article.
Well, there you go. There you go. A lot of good
And
options.
you're gonna write some of them.
Well, there you go. I know.
Okay.
We're going to write them about lawn art.
And, all right, then, we will move along then.
Well, I'm looking for a resolution, folks. I know it takes a while, but we're gonna get it done. So, because if we just postpone.
Do you want
it-
to take them separately?
Yes. Let's look at paragraph 1, which was taken from 5.1 already.
Mhm.
Do you want to install it here under the compliance anyway, or let it speak for itself
Yes.
in 5.1? Discussion?
Oh, the bow legs around 5.1?
You
Yeah,
just need to
as
put it-
reference.
You just need to.
Yes,
Yes.
I can do that, but I don't want to mess the computer up right now.
Because it absolutely belongs in 5.1.
Yes.
That's what it is.
Yeah.
Right now,
Right.
in the charter.
As fine as it stands, it just needs to have a,
Yes,
Mhm.
okay.
Yep.
okay.
Good.
Well, so the committee thinks it could be in both places in the charter and that's acceptable, or not?
Compliance and enforcement, yeah, I don't see any reason why
We're
not.
repeating ourselves, I'm
I
just
know.
asking a question. We're
No,
making the
I
charter much longer.
understand that, I do understand that. My biggest problem is sometimes you have to repeat yourself in order for somebody to pay attention to the 5th time you said it. Yeah, no?
Well, because it's the same language, it's not controversial. It's an administrative issue, you might say. So do you want to take a vote or more discussion?
I'm willing to vote on
Ooh,
it. Kathy?
I'm
All right,
okay.
all those in favor?
I'm good with it.
All right,
Okay.
so we're accepting this
Good.
section. How do you want to approach the second paragraph that starts out for inspection purposes?
Now, is is the landscape cleaning, painting and all that stuff, is it anywhere else? Is there a small handout,
It's in the design guidelines.
Yeah.
design
Well, the
guideline?
design guidelines is this thick.
No, it's not that.
Well,
It's not
but,
that big.
okay.
Like I
it's
said, there's
that-
24.
Break my heart for 2 inches.
Yeah, there's about 24, 26 design guidelines in Celebration. They're all on different topics, from fences to mailbox to painting. Each one is a
To
separate.
exteriors, to architecture,
Yep.
To cleaning.
certain colors of homes allowed
Exactly.
only such.
And every month in Celebration News, you'll see one of those issues highlighted in Celebration News.
Right.
This month, it was about what type of roof to put on and how to keep it clean. But we've also written about painting and cleaning sidewalks.
Okay.
We talked about fans and door hardware. It's all in the design.
Fans, you're talking about like porch
Outdoor-
fans?
Porch fans, outdoor ceiling fans.
Okay.
I'm of the opinion, I think Kathy was.
I'm a no, I'm a no.
is
I don't think this is
taking- is not
necessary.
putting this in there.
I don't think it's
No,
necessary.
Because I think it'll change
Mhm.
as in 10 years. So now what I'm looking at is, do you want a leading sentence similar to this that references the design guidelines, or not say anything at all?
I just would end it, my vote would be, we take this paragraph, and I think we strike, we do not include the rest of that.
Right, but I
Second
like,
paragraph.
I agree, but I also like adding, please see for reference the design guidelines, where we want to send them to go read about it.
So leave that line in?
Well, something similar to that.
Similar, not quite that line.
We'll have to rewrite it.
But does it need to be in a charter? Again, I'm stepping back, and if I had a question, I would probably come down to town hall and say, excuse me, Susan, can you help me with this?
Yes, let me
That's
introduce you
what I
to
would
Laura.
probably do. I mean, I have a question, can you help me find this answer? That's probably what I would do. I don't think I would look for a charter for that answer.
I have to admit, that statement I would agree with. I wouldn't pull out a 142-page charter to look for that.
I'm not, I don't even know where I would find it.
You know.
Yeah. I mean, I do now, because I've got one in front of me.
It's enough to know that I
But-
have to be compliant, which the charter explains very well. But
And if we're not compliant, we will know, correct?
Oh, yes.
Someone will tell us, so we will figure that out and put numbers on our mailbox, because we didn't have them on the mailbox. I'm not saying I'm speaking from experience there.
I've gotten that letter too,
Yes.
so I was on board.
So we figure out how to do it.
I've heard from Bill and Kathy spouted that Leslie, do something similar or nothing at all?
I'll say nothing at all then.
All right, ready to take a vote? Do we leave in a modified sentence? All those in favor? One. Do we eliminate this sentence altogether? Okay, majority. So this is taken out. Okay, all right. I'm ready to move on to, I guess it's page 6 now. And now we're into rules C, which is the, pretty much rules and covenants.
Okay, in this particular area, as to what you see here as the strike-through, is what is the current language that is in the document
For parking.
for parking. Now, one of the things that just jumped out of that is that we've had many opportunity to deal with something that's been for 4 hours. If nothing changes, recommendation is to move that to 8 hours. But that is the current text that is up there right now.
Now, you may not realize this, but for the staff here, tracking number 1-10, we've already made modifications to this on the 12th of June and voted and accepted what you see right here.
Okay, well,
You didn't know that.
we didn't know that, but this is what we
Right.
worked
So
upon.
it's considering, but I just.
Here's partly what, some people will say it's redundant and that it sounds something like an ordinance. Well, it does have the basis of an ordinance. The ordinance is that of Osceola County. And the issue of that is that if you put it in the charter, as in restricted activities or whatever it is, it then starts the process of that town hall can then immediately, or in conjunction with, talking to Osceola County Sheriff's deputies, can come down and cite. But this puts this in writing as in more greater specificity. And that's where we've had many a discussion with board members and with homeowners and particular things. Where this was drawn from is from other locations, and this is how they've defined it.
Yeah, that's right.
Now, what it is it is in greater specificity, but what we're having to deal with is that there have been issues of what's a recreational vehicle? What's, how long can it be there? Can it be parked overnight? Any of those particular things. Can it be seen from the driveway? Can it not be seen from the driveway? And what we're trying to do is to give Town Hall, the inspectors, or be able to react to a phone call from a homeowner that we have the basis of this, and that's the purpose of this. Now, you had a discussion of what is a commercial vehicle. We've gone into a little bit more definition as to what that is. And so I'm just saying that for your consideration, since we worked on it a little bit more, I think, than was asked of us, but we didn't know that you were working on it also.
We've, unbeknownst to you, we've also had a meeting and discussed the definition of a commercial vehicle in Greg Phillips' area, and we decided to move that to a separate item.
When?
I'll have to find it. I guess it's at the very bottom. Yeah. This is tracking number 1-3. And we looked at this way back, the task force voted on this on the 29th of May.
Right.
And this is what we accepted and made commercial vehicle. We separated it from parking because of its location in the charter and made a separate
Okay.
rule for commercial vehicle. We made it simpler. But I'm not trying to dissuade you from your good work here because I think it deserves consideration.
I guess the question again for me, is there any place else I would be able to get this?
No, there isn't.
So there's no rule or anything?
Is it from Osceola County?
Well, it's just standard Osceola County parking,
Well, there is a place I can get it. Online,
Yes.
Osceola County.
but that would be to go to the county.
Yeah.
Now, we're saying as a homeowners
Nothing
association,
charged.
Yeah.
Well,
Oh, according to this, 7, yeah.
right, yeah, that's where commercial vehicle was defined in the charter.
Right.
And on May the 29th, we voted to move it to a rule. So it
Okay.
would be easier for the board.
So this could become a rule versus.
Well, it is a rule.
it is a
Oh,
rule.
okay, all right,
He's
okay,
voted-
got it,
Yeah, it
gotcha.
is a rule.
Yeah, we
Gotcha.
voted for it, yeah.
Yeah,
you're
but
right.
we, unbeknownst to them, we actually already considered it.
So what's the difference between what we considered and what's,
Well, do you want to talk about parking or,
or could you reconcile that, Gary?
well, we
Maybe.
can, but I'm going to ask you to do it real time. So the question is, do you want to look at commercial vehicle first or parking? Because it's two different issues. You tell me. We can look at commercial vehicles because it's shorter. It would involve the last 4 lines of their input.
So if I were the attorney sitting here, would he say Osceola County supersedes anything we write here?
No,
You
because
wouldn't?
Celebration has more specific issues about parking and commercial vehicles than the county.
Correct.
Because we're a community that is upholding an aesthetic standard. So a little more specific.
But we can't make something legal that the county.
Yeah.
No, and that's not what we're doing.
Right, no, I just want to be,
Yeah.
I just want to clarify.
Yes, sir.
What we're doing is that an assistance of town hall. We're providing very specific guidance as to what they're trying to enforce. And if we have something that is not as we're stating it here, and we need the backup of Osceola County to try to get someone to comply, we then have that ability to do so. This just becomes the closer to the homeowner, this is what we're saying as to what the standards are.
As a show of difference, this definition of commercial vehicle is a commercial vehicle that weighs more than 3/4 of a ton. That would be 1,500 pounds. Unless you have a Yugo from the 1970s, every car weighs over 1,500 pounds. So our definition of commercial vehicle is curb weight exceeding 3¼ tons, which is what the charter has said for the last 10 years. And that eliminates people with a pickup truck with 4 wheels on the back because they haul a trailer. Because a lot of us, I don't have one, but a lot of people have those big pickup trucks, and for them, it's a vehicle. It's not a commercial vehicle. So there's one difference there that I would point out, that I wouldn't accept a definition of just 3/4 of a ton.
Well, no, it doesn't end there, comma, vehicles outletted with ladder or equipment
Well,
racks containing.
But it is, commercial vehicle is anything over 3/4 of a ton, and that would be all of our cars.
Very
That-
No.
That's pretty,
I say just go back to it kind of feels like the group home discussion to me a little bit, right? We can have all everything we want in there, but if the law says, this is what the law says, that I can park my vehicle, I mean, so we can't supersede Osceola County ordinances.
well, what
Right.
I'm asking you to do,
So it would say in accordance with,
well, if we say that, then we're giving up the aesthetic standard that we've already set in Celebration.
but can we enforce it is my question.
Yes?
Yes, you
We
can.
get violations all the time, and we enforce it.
Okay.
Yes.
Carrie, can I make a suggestion? Because this has been something that's already been addressed to some degree.
Mhm.
Why don't you look at the 2 areas that you were talking about and seeing if there's a big difference between what you have? That way,
That's-
because it's already been, you've already approved those other changes.
Totally agree, that's what I was getting ready to recommend. I would start with commercial vehicles because it's shorter, and we made it a separate issue. So here's what we agreed to on the 29th of May as a commercial vehicle. It's defined by one or more of the following criteria, and we're prohibiting them from overnight or weekend parking in the residential area, period. And then these issues. So now let's take a look at the last part of page 7 here. Commercial vehicle, the term commercial vehicle shall refer to any vehicle weighing more than 3/4 of a ton. Well, I wouldn't agree with that because all of our cars weigh more than 3/4 of a ton. So there's a difference that I would agree with.
So why don't we just stick with what we approved
Well,
already?
would you like to, rather than throw it out, I would give them the benefit of the doubt and see if there's something that is of interest to us. I'd like to not overrule them and just say there may be something that we didn't consider. So if I take that out, because it would be, all of our vehicles would be a commercial vehicle, and that's not true.
Mhm.
Then the next phrase is vehicles outfitted with ladder or equipment racks or containing visible tools, equipment, or room tone. Well, guess what? That was what we wrote here. Vehicles outfitted with work equipment intended for commercial use or transport. Those are very similar. Ours is shorter,
True.
but it's, would
Okay.
you say they're similar? Okay. Then after that, the proposal says, any vehicle on which a sign or other object is mounted for advertising purposes. Well, we say vehicles displaying a sign or logo advertising goods, services, or company name identifies a commercial vehicle. To me, that says the same thing.
Mhm.
Okay? Are we checking them off as we go?
Yep.
All right. Then the proposal says any vehicle displaying a name, logo, graphics, symbol, I'm reading between the semicolons,
Mhm.
Yeah.
or a message for purposes of advertising commercial brand goods or services, but shall not include public safety vehicles. That's pretty much the same thing here. It's just,
So what do you do with an an AP magnet on the back of a car? That's advertising an annual pass?
no, that's exempted.
Oh.
Okay. That's in that's what the attorney was talking about, right?
That's what he was saying.
Okay, and is that in this section, or I'm trying to remember where we put that?
Well, he just gave us that opinion tonight.
Right.
Yeah, so that's a
And-
hunt.
And that's, he just gave us the opinion.
Mhm.
I was going to discuss that next week.
Okay.
I've already written it down because he
Yeah.
gave it to me last week, but I didn't want to talk about it
Mhm.
until you had time to absorb it, so it's on the agenda for Tuesday.
Okay.
And he provided
His language,
his input,
right?
which we can add, which would, again, would amplify what they've written here and give us the exemption for that little AP sticker. And it also would exempt governmental quasi-bodies. So the end at the top of page 8, that covers everything that they put down to the period after governmental bodies, except we discounted the 3/4 ton, and ours says 3 1/4 ton, which I think is more descriptive of a commercial vehicle. So now reading what the proposal says, for purposes of this subsection, a vehicle shall be considered stored or inoperable. Well, that's a whole new subject. Do we talk about stored or inoperable? No. We have to go back to parking. It's not under commercial vehicle.
Right.
So now let's see if the current charter says anything about stored or inoperable, parked outside for a continuous period of 30 days or longer. Oh, here it is. Stored or operating vehicles in places other than enclosed garages, except temporarily for a period not to exceed 4 hours for loading and unloading. That would be like a moving van.
Mhm.
And it doesn't apply to construction. So guess what? Our current charter doesn't talk about
Any of that.
inoperable vehicles parked for 30 days or longer, or parked outside of a garage. So this is new. The proposal has something new. That's why I didn't want to throw it out. We should consider it.
Yeah.
No, I agree. We have had that experience in our neighborhood of cars that don't go anywhere for a month at a time.
2 years. Sorry.
Now,
So let me ask you a question of that. That's good, though. That's a good example. So could you call, what would Osceola County do about that? If you've got a car, what should they do?
If it has an active tag
Okay.
and.
I'm just curious
Jer-
what the-
Jerry, we had a car parked across
Yeah.
Town Hall that was there for
Yeah.
at least 60 days.
Right.
And there was not one thing he could do about it
Yeah,
because it
okay.
had a valid tag.
Okay.
And it's gone now,
Yeah.
so
No, just
hooray.
move around the corner.
Yeah.
I haven't looked over there yet.
It's the owner of that house.
Yes, yes, yes.
So just, let's pull that thread through, because I'm curious, because I think we all have seen one, right? There's one around the corner from me. So what can you do about it?
well, if you adopt this in the charter,
Okay, so we
Then it
adopted in the
becomes-
charter, what can you do?
then it becomes a violation you can cite, and if they don't do anything about it, they can actually be fined.
Okay, you get fined and fined and fined and
No, we
fined.
can't tow it. We can then, it's a violation, it would then go through the process. If it reaches the point of a hearing, the hearing, all parties would be considered, and then the committee would then, well, actually, it goes to the board first, then it would come to the committee. The committee then does its investigation with town hall, then a recommendation will be made for either to fine or to not fine.
So really, fines are the only way that,
Quick question, Susan.
The car's still
You
there.
have a pretty large depth
Yeah,
of
we had
knowledge
Jerry
with
come one
regards
time.
to this.
Can do it again.
What do we have available if we add language like that to the charter? Do we have any legs with it?
yeah.
We can't force them to move it other than fining them. And I think that, they're going to come to the board and they're going to say Osceola County doesn't have any restrictions on that. Osceola County, there's nothing we can do about anything that's parked on the street
Right.
except for, RVs and stuff like that.
But if this is incorporated, you can cite them as
You
violations.
can cite them, and you can find them.
That's right.
Can you cite them now, though?
But if it went to court, they're county roads, and it wouldn't be upheld.
That's exactly right.
I mean, just the enforceability part, you know, we say 30 days or 15 days, or whatever number we put. And the guy says, oh, I drove it away. And I brought it back. I went to the supermarket, came back, and you just didn't see me move it.
Yeah.
Well, we deal with those particular things every month.
But it is harder to
Yeah.
catch.
The issue with this is the fact that it's along the aesthetics. It was the discussion of, like you said, you can't have commercial vehicles in the residential areas. Okay. The homeowners have decided that we don't want to have commercial vehicles. We've established a standard. Though Osceola County doesn't have any enforcement on that, if we were to take that line of thought, they can park them anywhere.
Yeah.
And so all that we're doing is that we're establishing an aesthetic, you know, that car's been there. it's
That's
got a cover
completely
on it.
unenforceable, though, unfortunately.
It's enforceable only if you put it into the rules that it
To a
becomes.
fine.
To a
You still
fine.
can't move the car.
We can't move the car, but it becomes an item of which you're trying to convince the homeowner.
Right.
It can be fine. And the commercial vehicle rule being overnight, that has been on the books for years. The celebration has been cited, they've been fined, they go to the board. It has been upheld by Coral Board for years because it only exists in our charter. It's not in the county law.
But it's also something that has been proven in law that we can do that.
Yeah. Because
It's aesthetics.
it's aesthetics. So you could say this stored and operable for 30 days, flat tire, that's aesthetics. So I would think it's enforceable.
I think the aesthetics conversation can get a little dangerous because we can walk downtown and see a lot of aesthetics that aren't being
But we do
maintained.
that now with commercial vehicles.
Yeah,
For
I get
over
it.
10 years,
Yeah.
we've been able to cite commercial
Right.
vehicles and have the
Mhm.
fines being imposed. Am I wrong?
Just not downtown. The residential.
Residential, yes.
Correct.
I didn't say downtown. but It's enforceable in residential properties and has been.
And most of the time, someone just isn't aware, and they're going to take care of it. I mean, that's what,
Right.
the people who move into Celebration typically are those people.
Assume the best.
It's an aesthetic standard, and this stored and operable flat tire thing is another aesthetic issue that I think would be enforceable at the Coral level.
And it's inoperable at that point in time, and so Osceola County may do something because it's inoperable. May not even fall on us. Osceola County would take care of it.
But moving forward, we're really thinking about the last four
Yes.
lines up there.
That's
They
right,
may.
because everything else under commercial vehicle is pretty much incorporated already. Now, we still have the other page to talk about parking, but this, right now, I'm focusing on.
But if we're going to
this-
vote, it would be on those four lines,
Right now.
not any, okay.
Yeah, right now. There's other issues on the previous page we haven't talked about.
Hey, Gary, really
Yes.
quick, it's 8 o'clock, and we have 2 staff members here, we need to
Yes.
be aware of that.
Yes.
So I would say no more than 20 minutes, and we need to at least let staff
You
know.
know, I was gonna.
Could we table this to,
10 minutes, perfect.
could we table it to a task force meeting where, because I'd like to hear from other task force members, quite frankly.
No, we can do that, and it's time to adjourn, but that's what I wanted to do. I hope you understand, this takes time. We're at the point now where we can't keep kicking the can down the road. So I like looking at things line by line to see what the inputs are. We found something that we like, and then the rest of it is already there, so you can make an intelligent decision. I just don't want to throw out an input because on its face value, we need to dig into it and look at it like we do everything else.
Yeah, I think it comes down to where does it belong? Does it belong in a charter, or does it belong in rules, or, you know, is it?
Well, the rest of these are rules.
These are
Yeah,
rules.
yeah, this is a charter change, though.
No, no, this is
Oh,
rules.
it's rules. Oh, I'm sorry, I keep thinking we're in charter.
No.
Thank you,
it's
okay,
rules.
got it,
Okay.
got it.
So,
Okay.
for the moment, would you agree that we've covered the definition of commercial vehicles satisfactorily? Bill?
Yeah.
Kathy?
Yeah.
Okay. And now we're talking about this last 4 lines. We're going to table them for now. And we have yet to discuss parking, page 7. So, I would say what I'd like to do is what this means, Steve, is you're gonna come back and.
Really?
Yeah. Continue.
Is that what that means?
We got 24 pages to go, Steve.
I know.
Do you have any, I'm kind of trying to do some brainstorming here as to how, because there are some very important contributions that are in here.
Yes.
And my concern is that we're gonna get glazed over.
Yep.
Totally.
I got glazed over too.
I have no doubt. So I really feel like we need to figure out an efficient way so that we can, as the task force members, perhaps we can have these available online for residents so that they can actually view these. And then the task force members obviously have access to it. And then if, based upon this, maybe individual task members can kind of say, hey, I saw this is something that's important, I think needs to be inserted in there. And perhaps we can kind of filter through this a little quicker. Unless somebody else has any other ideas, I'm just brainstorming on how to help this go more efficiently.
Honestly, that's what we've been doing for the last 3 weeks. The task force members have had these inputs since the 21st or thereabouts of June. That's a month.
Right.
And the only way to get through it is for all of us to look at each line to see the value of the input. Or, and I haven't said this yet, have one person sit down and highlight the differences if you trust that person, and present it, if you trust that person, to present it fairly. But we still have to sit here and look at each individual line, whether that's done or not. And I would submit that we've already done that. I apologize, I'm going to say the wrong thing. We all have homework to do. And if it wasn't done between the 21st of June till now, then shame on us.
Then we're looking bad.
Yeah, I think it's a little deeper than that, too. I think there's philosophical conversations here of, rules are rules, and we get rules. Where's the line of trying to account for every little issue that we don't like in the community versus... Well, I understand that, but I think I'm philosophically having a debate that I think you can get ridiculous with rules, especially rules that we can't enforce at the end of the day.
It's all about aesthetics.
I get that, and I think that's a rabbit hole that we need to be careful with too, with aesthetics, because I think a lot of people would look in the community and say, if there's a lot of aesthetics that are bothering me right now that aren't being taken care of, what good are the rules doing, if I can't fix this, right? So I just think we have to pull the camera back. I kind of like your idea of, could we at least highlight? I mean, I don't know, I can read through all of it, which I did, but I'm philosophically, trying to say, what's best for the community, I mean, what are the best decisions so that and if we don't like something, are we going to put a rule in? If we don't, where's the reasonableness of this?
That is expressly our job.
Right, I agree.
Is to look at the rules and the aesthetics of this. I'm going to preach a little bit. Celebration was founded as a community that is aesthetically pleasable, that has these rules which keep it that way. And now, and if you read it, that's where we are. Now, where was it going?
I don't know.
That's where we are. Now, oh yes, if all of us can cite multiple issues, if we walk out on the street in our own neighborhood and go, why isn't this taken care of? And it boils down to a couple of things. One, you need manpower and staff to look for all that. And sometimes you don't have enough manpower. The community's quite large. And the second is, it takes time for every homeowner to correct the problem. We're all not efficient about paying
And
the
third,
house.
there may be nothing you can do about it, right? I mean, we live in Osceola County.
Well, that's true, but I try to make a point is, we've lived under this commercial vehicle rule for decades
Right.
and been able to enforce it.
Mhm.
So there are things you can do that's over and above the county ordinance.
Mhm.
And that's what makes our community and many other gated communities different than the county. We could go live in the county, but it may not look and appear and react the same way as our community. And so it's that balance, it's how much is enough and how much is too much. And that is expressly why we're here today. We, the seven of us, have, with input from the community, and we're representing the community, have to make a decision on what do we want to do. Pardon my preaching here.
Now, one thing I gotta go back to, and we're gonna end this,
Yeah.
is the fact that I am not the smartest person in the room, and no, I did not sit there and write these things, okay? I went out and found communities which are like us, as much as like
And
can
his
be,
team members do the same thing.
as to what they can be, and this is where I pulled from their sections of which is the equivalent of it, and they are in their documents.
Part of
And
it, I'm sorry, go ahead. I
But
apologize.
that's all I'm saying is,
Sure.
look, I'm not a lawyer, I'm not doing it. All I was doing is to look as to like, and to sit there and to try to bring clarity and specificity as to what is to help the standards department of town hall be able to do their functional mission, of which they've had challenges. Now, the challenges of what they have been faced with, he's already alluded to. We'll address those with the board, be it the committee, be it budget, be it other things that we need to do with that. But I felt, as the chair, that we needed to have greater specificity, because there has been some walking around, be it these rules or the exhibits, as to what's going on. Yes, please don't, I don't have my military uniform on, and I'm not living on a base, post camp, or station. But Celebration was built upon very established, stringent guidelines. And what has happened is we have a lot of plank owners, the first ones that are here, that are saying, when Disney was here, this is what it looked like. And it doesn't look like this anymore. Because the standards are not either being maintained or
We're aging.
The community's aging.
and the community is
Exactly
aging.
right.
Now, with that, that's why I'm saying, with that largest component of that is an aging community, the structures and everything around us, is the fact that I'm just trying to close the aperture a little bit more so that we can force, I'm not saying
Well, I
compliance.
was here when Disney opened this community, and yes, it looked very different. And I would say, when people say it looks very different, personally, I think they're talking about it downtown. I go around neighborhoods and it looks just the same. It looks better, quite frankly. The trees are grown in, but there was a Goodings on the corner, and that's not there. So I think we have to be careful when we, what are we looking, are we trying to solve for a downtown issue, which we know we have a significant downtown?
This,
Or Artisan Park, or
yeah,
South
again,
Village. or-
I'm looking community-based.
Yeah, got it.
Okay, I am not looking at a particular village or the downtown. This is just the comments that have been received,
Yeah.
and go from there.
I'm just gonna make one quick clarification. Part of the disadvantage of looking at documents now is we have to remember that those documents were originally drafted
Yes.
when the community like ours was first in the inception of it. So you are able to have all of these detailed information in your documents as your owners are coming in.
Right.
We're trying to edit something, and back to that point, if somebody tells you, well, wait a minute, I can't park for more than 4 hours, well, I didn't know that.
Yeah.
Well, but now you're pointing it out to them and you're wanting to change it, and they're like, well, wait a minute, I don't want to do anything with it. My fear is that as we point out these more fine details,
That's right.
that people are going to look at it and they're like, I'm not voting at all for that. And then we're really screwed.
I really concur with that, and I think that was the conversation we had earlier when we were talking technology, is that in a charter, less is more, right? There's other ways to do enforcements. But again, if you wanted to pass it, that 4 to 8 hours could be a big, I think your point is well taken. Lawn art matters. You could have it go down because of the word lawn art.
I want to wrap this up. We're all reasonable people, but times change, so as we're rewriting the rules now, we're incorporating our view of life in our community. But we do want to respect what was before.
Sure.
And the fact that it actually worked. So there's a fine line here, and then finally I'll say, when we're done with this, hopefully we'll have reasonable changes that we can educate and educate in an affirmative, positive manner that people will be willing to accept it.
Yeah.
Okay. So
Agreed.
with that, I'll adjourn if that's acceptable.
Sure.
Right, so,
We'll pick up Tuesday.